to do the honor of guiding the session of today's program. Thank you, sir.
Thank you, sir. It is my pleasure to be with you in this morning of 19th August 2023. I express my gratitude to Honorable Chief Justice Mr. Justice Vishwanath Samabdar, Chief Justice of Sikkim High Court, and also Sikkim Judicial Academy to give me opportunity to share some of my thoughts and interaction with you, so that it would be a both-way learning session. It is not that I will just delivering some lecture and I will not hear you. The subtopics which being arranged to discuss, I will start to some extent devise and change one aspect, that there are almost 8 sub-themes: victims in criminal justice system, rights of various parties in criminal justice, constitutional remedies under criminal justice, good governance and implementation of criminal justice system, and session 2, how to strengthen criminal justice administration, role of judges, magistrate in criminal justice administration under CRPC, rehabilitation, compensation and victims protection in offences of human trafficking with special reference to human trafficking, role of government stakeholders in rescue. This victim in criminal justice system I will take in the post-tea break, and I am taking the first session of the second session, strengthening criminal justice administration issues and challenges, in the first session. Other things in the first session will be covered by our first session. It is not that we'll go mostly on paper or sections, but mostly on how we perceive criminal justice in the background of Indian criminal law, particularly CRPC, also Constitution, because Constitution is our foundation and values. For that I will first take up the criminal justice administration as a whole, keeping in view all this aspect for our discussion. I will prefer to be there. I think microphone will not reach. I have seen that majority of you are from women. It is a, I think, recent trends in West Bengal also. I have seen in judicial service that women are coming in the judicial service in more way. In my time, out of 100 girls may be there, but now in our university also, more than 50% are girls students, so it is a very, I think, positive sign of our criminal justice or justice system. Not changed by previous institution. Then what we are trying to discuss in this slides: basic concept of criminal justice, criminal law, characteristics of criminal justice system adopted in India, the criminal laws, legal framework of criminal justice system at operational level, and to identify the features of criminal justice procedure in India under Constitution and Criminal Procedure Code 1973. Now, if we say that criminal justice and criminal law, how you differentiate criminal law and criminal justice? When you say criminal law, normal concept that there must be some punishment, but that is only one. There are other three aspects that will also know that. And there are some characteristics of criminal justice system in India also. That also. So that the philosophy, the principles which govern our criminal law in operational level, in practice, when you are implementing, if you keep that in your mind, it will be easier and it will be the right approach to deliver the judgments. Now, when we say the criminal justice, definitely first term is crime. When we use the term crime, according to Jerome Hall, 7 ideas and elements are coming. That in every crime there would be harm, it is presumed, and it is outlawed. Outlawed means violation of law. Some violation of law, it may be acts and omission prohibited by law also, we can say. Then conduct. Act or omission, these both are conduct. So when we say crime, there must be some conduct. That also we have to keep in mind. After that conduct, the next thing we have to keep, that whether there is any guilty mind or not, which we, in other words, in our legal terms, say mens rea, mental elements of the accused. Fusion of mens rea and conduct, you know, in IPC, some definition, it is not only the mental element, but action also, like theft. When dishonestly moved, dishonesty is there and moving of the object also there. So both combinations are there. So these two sometimes being mixed, fusion. And causal relation, like sometimes we have to justify whether there is any justifications, provocation or not behind a crime, or there are some other reason, necessity. Some justifications are there, whether there is the presence of justification or not, that we can also find out by relation between the ultimate happenings and the reason behind that. And of course, punishment or sanction. In my experience with many interviews, when I ask student or a candidate coming for any selection, either teacher or sometimes I was in UPSC also, PSC, that what is the characteristic of criminal law? They are all saying that punishment. I ask, punishment is also in Factory Act, in Companies Act, in SEBIs, in other also. So wherever there is some punishment offences that can be criminal law, they are confused. So we have to keep in mind there are other elements that we have to again identify. So when we say that, how we say that a legislation is criminal law or not? And if it is criminal law, then only it will come to criminal court. If it is civil law, it will not come. What are the characteristics of a criminal law? This is the classical concept of criminal law, that there must be 4 characteristics. First is politicality. Politicality here means that it should come from sovereign political authority through its legislative organ. Criminal law can't be promulgated or can't be made by any government department or any statutory body or our university or any establishment developed by a law. It is only by sovereign political authority. In our country there are two sovereign political authority, parliament in making of law or state legislatures. So criminal law, when it would be criminal law, it must come from the political authority. Here means legislative organ, not any department, any statutory body. The second is specificity. Whether a person committed crime or not, and what crime. What do? We normally look into our penal code. Whether any of the definition of offences comes within the conduct or incident, and whether all the incidents, all the criteria, all the elements of a crime present or not. Accordingly we characterize whether it is theft, whether it is extortion, whether it is dacoity, whatever may be, by the specific characteristics definition we have to identify. So specificity is with there, that what is theft, what is dacoity, what is robbery, what is culpable homicide, what is murder, what is rape, all this specifically mentioned. There should not be any vagueness on the characteristics of a crime, and uniformity. Uniformity means criminal law be applicable to every citizen, rich or poor, whatever may be the status, except those who are in the high government position. During that period, like president, governor, you can't initiate any criminal proceedings. But after their office, you can do that. Except that, criminal law is applicable to any person in the country. That's why it is universality. It will be applied universally to everybody. Opposite to that, let us look into company law, our contract act. It is not applicable to everybody. Those who are either the shareholders, directors, it will affect them only. Or those who are dealing with that company, them only. Or contract, those who are entering into contract, they are only affected, not all. But criminal law, everybody is under the criminal law. So that's why it is uniformly applicable, uniformity. And of course the common one which we know, penal action, sanctions should be there. In criminal law there must be some punishment. It may be imprisonment or fine, forfeiture, whatever the prescribed punishment. So all these four, you remember, must be there to identify whether it is a criminal law or not. But why criminal law being passed by our legislature? When criminal law being promulgated, what are the background and why? It should include a behavior, some behavior not acceptable to the society, that being prohibited. Now debate is going on that homosexuality is offense and whether it can be legalized or the marriage between the gays can be same sex be recognized or not. So it is dealing with some behavior. Unless that behavior prohibited by state through law, criminal law, that would be treated as, not be treated as crime. The moment it is being accepted by the legislature, declared or promulgated by the politicality, that is the sovereign legislative body, then only it is criminal law. And sometimes the behavior of the society or human beings, some people in the society require to be prohibited and controlled. It is another way, social control. In that purpose, we have criminal law, we have to develop criminal law. But there is a debate sometimes with how far public order be controlled by the state. In some state, prostitution is not crime, homosexuality is not a crime, and attempt to commit suicide now is not treated as crime in India. Sometime it was thought of. That means society, if sometimes behave some way which the lawmakers thinks that it should be prohibited or it should be decriminalized. Decriminalized means it will no longer be treated as offense, like our attempt to commit suicide. So it depends upon the social development, whether one conduct be treated as crime or not, whether it will be prohibited or not. In fact, our development of criminal law, we can see through two doctrines. One is mala in se, other is mala prohibita. Mala in se, for example, murder, theft, dacoity, robbery, offense of rape. These are mala in se, that it are by the conduct itself being prohibited in the society from the very beginning. If you go to early stage of development of law, you can see any country, these are the crime. And it is not that, because when there was a kingdom, no parliament was there, but for murder, king can punish, even death sentence also. For theft also, punish the wrongdoer. But gradually when our civilization grows, many human conduct require prohibition or control. If you look into, you have the experience, many of our legislation today in the parliament, prohibition word also used, like Child Marriage Prohibition Act, or that Prohibition of Food Adulteration Act. Prohibition word also being used. That means it was previously from our society not being treated as crime. But after some development, because people behavior developed in such a way that food adulteration require control, prohibition is required. Or simple way, we can see driving of the car is not offense, but driving in excess of speed, and if you make accident, it will be offense. There is conduct being prohibited and controlled some way. Today, most of the new legislations are prohibition, your conduct being prohibited because of some social development, economic development, like the last legislation placed in our parliament. That is our data protection law. Data protection law, data protection and privacy law, that is whatever your own personal information data that anybody can't take without the legal process. What is going on now, Google or others, they are taking your information and they can deal with anybody else. That freedom is to some extent now looking into to be controlled. Or data which or information stored in the government or in our defense, that should not be misused by anybody working there. It should not be given to foreigners or any others. A new behavior because of this internet age, lawmaker thinking and law is being developed. So criminal law also, some are due to our social, economic and also technological development, we are developing, and it is one type of prohibition of conduct. Because crime, we have seen that it is one type of conduct. But we remember there are few crimes offences which from any society these are treated as crime, offence. But I am also using the term that criminal justice administration. You are also part of criminal justice administration. Judiciary is one of the limbs of criminal justice administration, pillars of criminal justice administration. There are others, police, prosecutors, in criminal law, defense counsel, and also after judgment we have to go prison and correctional administration. So all are the agencies and part of our criminal justice administration. So when we say criminal justice, what is the aim of the criminal justice? Is that guilty should be detected, convicted and duly sentenced. Here convicted means if guilty not found to acquittal, but ultimate object, if there is crime, that we detected, then convicted and duly sentenced. Why I have not write sentenced, but duly sentenced? Why? Why duly word is used?
Because we have to consider all the aspects, facts also, past antecedents.
Yes, we have to consider all the aspects before decision of this, because sentences are not fixed. It may extend to 3 years, it may extend to 5 years, 10 years, whatever. And what particular punishment required in the particular offence, considering the circumstances of the case, the age, character of the person and others, mitigating circumstances or aggravating circumstances, you have to decide. So duly sentenced, and that means actually sentence which fit to the person, not the crime. In our kingdoms there is punishment against crime. If there is a theft committed by a person, the hand with which he committed that theft, his hand will be cut off. When a person, there is a homicide, the person kill, the kings of the survival can kill him also. So this type is not there. Now every sentence fit to the criminal. Same crime, theft example, if committed by a young person of 25 years and same amount of money committed theft by a woman having a child of 1 year, court must not award same sentence. Court has to consider what fit to a particular situation. And when we say criminal justice administration, mainly the procedures by which substantive law to be implemented. Our substantive law is IPC. How this IPC be in motion, that IPC just prescribes some offences. If any person committed that offence, then it will be initiated by the police and criminal justice administration, that criminal procedure to be followed. So, in other words, we can say criminal justice is implementation of substantive law, the procedure to implement the substantive law. No, criminal justice system, two types. One is inquisitorial, other is adversarial. In our country, what type of criminal justice administration we follow? Adversarial. Because inquisitorial system, investigation and interrogation carried out under control and supervision of the court to ensure that innocent person is not subjected to trial. But here in adversarial system, the person presumed not guilty and the prosecution is to prove beyond all reasonable doubt the guilt of the accused. And this system presumes that best way to get the truth is to have contest between the prosecution and the defense. That's why our system is adversarial. But is it that all the offences we have adversarial? There are few where inquisitorial also, like cases of offence against few cases of offence against women. Inquisitorial there, or NDPS Act, inquisitorial element is there. But in majority of the cases, it is adversarial system. That person presumed guilty. Is there any connection this adversarial system with our constitution? Why we are following adversarial system? Is it that it based on our constitution? Yes. Because our constitution, in our common language we can say, aspire or propagate a fair trial procedure, where all persons before the court to be treated as innocent. Equal opportunity be given to prove whether he has committed offence or not, both prosecution and the defense. What is in inquisitorial system? Person presumed guilty. He is to prove that he has not committed the offence, like in some of our offences also. And in adversarial system is also known as our due process, that every opportunity to given to a citizen to prove that he is innocent, and also that our equality principles be applicable to all citizens. If a person committed offence, under 12 persons, in many judgments in Supreme Court clarified that a person in jail and person outside the jail or outside the prison, both are entitled to Article 14. Article 14 is equality before the law. Until and unless a person proved that he has committed offence, a person under trial and a person only when he is under trial, his freedom of expression under Article 19, that freedom of movement, these are restricted. But his right of equality, 14, or other fundamental rights, right to life, if there is a torture in the prison, then Article 21 basis there would be cases against the law enforcement authority, police. So we have to keep in mind our constitution is the base by which our adversarial system we are following. Now, your adversarial system also raise the question, what model of justice, because you know our preamble of constitution promises justice, social, political and economic. So justice is one of the value of the constitution. So what crime control model we follow? There are two types of mainly, but today it is also family model. One is crime control model. That anyhow in socialist country or social system of jurisdiction, criminal conduct must be kept under tight control in order to preserve public order. His individual freedom, his human rights perspective or his personal liberty, these are not at all regarded. That's why I am telling our constitutional rights being equal to person outside the prison and inside the prison also. So that is not being followed in our country, but our country followed due process. It protects an accused from coercive, easy abuse power of the state. When a person is arrested or accused, in most of the cases cognizable offense, they are arrested during that period, so that his is not being abused. So it is one type of, when the countries which follow due process model, UK, USA, Australia, India, due process model, that here citizen when being arrested, he is giving all type of protection, being abused by the police or by the authority or the state. But there is new concept of justice model. To some extent we know the reformative concept. Here another group of penologists, criminologists, they are saying offender would be treated as a person with respect. Every person, human being, human dignity, that is human rights perspective, human dignity to be respected, and role of the society is to perceive an crime occurrence as criminal deviance. What is difference between a deviance and crime? Can anybody say? Deviance and crime, these two words. Deviance is just not obeying a social norm. But crime is deviating or violating the state law. So a group of persons saying that when a person committed an offense, normally he is a deviant. Deviant means he somehow during the circumstances but due to his economic situation or other mental health, he is unable to understand the law or the offense. Therefore, we have to take him that he is within the family of the society, one member of the family. If one member of your family having a disease, what you will do? You will leave him permanently. You have to treat him or her so that he may come to normal life. Similarly, there is another group of penologists, they are saying when a person committed offense, you have to think that he is one of our family members, deviant for some reasons, not obeying the norms of the society, but we have to help him, treat like a diseased person needs a doctor, we have to need a treatment by which he or she can return to normal life. That is a 20th century development of criminal justice, that offenders should not be treated as that they are born criminals. They become criminal or offender because of some socio-economic condition or some conditions. We have to give them opportunity to return to normal life. That's why we have reformative system. We have probation in your CRPC, and Probation of Offenders Act is there. Even after that sentence in the jail, remission of sentence is there. Even hardened criminal murderer having the right to claim mercy petition to the president and the governor. This concept is developed from this family model, that every person, whether offender or criminal, be treated as member of the society, like a member of a family. Now we are coming to Constitution. Now all your, though just few days back we have new bill, but we are following the 1860 IPC, 1872 Evidence Act, and previously 1898, thereafter 1973 CRPC. All are basically made during British period. How these are applicable? 372 of our Constitution provides that, or sometimes you may see that some legislations are prior to our independence. How that law we are still now enforcing. 372 says that all the laws in force in the territory of India immediately before commencement of the Constitution are to continue in force until altered, repealed or amended. Many times CRPC being amended, IPC also amended, evidence also amended, but that was continued. Similarly, other legislations also, prior to our 1950 when our Constitution came into force, our all legislations prior to our Constitution came into force or our independence be applicable in our court of law. Now what are the now laws regulating our criminal justice administration? We have to put Constitution as the top. Those constitutional principles guiding us. If there is any way you can show any of the provisions that it is in conflict with our Constitution, then that can be treated, declared as void. So Constitution and Constitution, wherefrom we get the concept of fair trial. The fair trial is from our constitutional philosophy, that every person be treated equally until proved that he has committed an offence. That philosophy, individual value, individual freedom, that to be looked into. And others you have also noted that actually 1860 IPC, 1872 Evidence Act, criminal procedure. And there are hundreds of special legislation also. Some special code, here also you have now POCSO also, I think you have, I have given here only one or two, Juvenile Justice Care and Protection, now it is 2015, and the PWDV Act also 2005. Special legislation, you have to sometimes interpret a particular word on the basis of not CRPC, sometimes on the definitions given in that particular special legislations. Like I am giving Juvenile Justice Act 2000 and now 2015 in adoption. In adoption, it is written that any child, whether belongs to Hindu, Muslim, Parsi, Christian, whatever, may be taken as adoption by any woman, including the unmarried woman, which is in conflict with our other Hindu laws also. But because it is special legislation, what is the rule of interpretation? But there is special legislation as well as the previous legislations. General law and special law. What will prevail?
Special law.
The special law will prevail. So that also you have to keep in mind that special law prevail over the general law. In constitution, we have certain philosophy, principles of criminal law also inside. These are first Article 20, protection in respect of conviction and punishment under ex post facto criminal legislation. Ex post facto means a law, if passed today, its effect may be given prior to that date. In civil, in some procedural law, it can be. But in criminal legislation, no provision can be implemented ex post facto. That means if Parliament today declared an act as offence, it will come into force the day it will be published where? In our official Gazette of India. Then only. It is not only after passing it will be law. After passing it will go to President. After President gives his hard assent now, and it will be published in the Gazette, India Gazette, then only it becomes the law. So it can't be ex post facto. No criminal law can be prior to date of announcement. All legislations, criminal legislation, be prospective in nature, not retrospective. Prospective, always prospective in nature. Then doctrine of double jeopardy. You know very well that if there is one offence committed by a person and it is in your court, the victim or prosecution can't take this, or the victim can take it in any other court. If it is a valid jurisdiction, there can be second file also, case in any other case. For one offence there can be two punishment. Double jeopardy you can have. The right against self-incrimination. Though Medical Identification Act 18 says that police for examination of by a medical practitioner can take the biological substance for evidence purpose, but in previous Selvi case, our Supreme Court says that no one is bound to give biological materials which will be against him, will be used against him or her. Incriminating, self-incrimination is not permitted. So that principle is in our constitution. No one can be compelled to be his own, against his own case, to compel him. And then Article 20, you know, the most important article, protection of life and personal liberty. It is being one of the living tree. Some in Supreme Court use that it is a living tree. We have to remember that our Constitution, Article 20, there are so many interpretations, hundreds interpretation, Article 21, right to life and personal liberty. So that is not a single principle you can say that Article 21 confined within this. Right to life and personal liberty, it is interpreted by the Supreme Court, Apex Court, various times by various judges in various ways. So that why it is said it is a living tree. Any way it can be interpreted, but the interpretation is mostly towards the citizens, or towards the, in case of criminal, it is towards the benefit of the offender. If there is a conflict between on interpretation, that or doubt, or if there is some lacunas, then court normally interpret in favor of the accused. Most of the cases, if there is some doubt, gaps, conflict, our provision or legal words not very clear, then court interpret it in favor of the accused. And that is the Supreme Court guidelines also. And then 22, protection against arrest and detention. And for that, from D.K. Bosu to last Lolita Kumari, so many judgments, guidelines by the Supreme Court in arrest. So there are principles to be followed when police to arrest and keep that person under arrest. And even after arrest, when he will be in the prison also. So during this period, Supreme Court developed certain rights which are not specifically in our CRPC. In D.K. Bosu, you know, there are some human rights elements already developed. In Lolita Kumari also case, Supreme Court developed certain rights that we have to keep in mind. So constitutional rights are the rights mainly to the accused, not mainly to the victims. That developed later on. We will come to that. Now, who are the criminal justice agencies? We have identified police, prosecutors, defense counsel, judges, defendants, victims, prison and correctional administration. So, all are known as criminal justice agencies, or all having some roles in criminal justice agency. Now, prison and correctional administration, not only after conviction, those who are under trial, to produce them before the court periodically, that is also their role. So everyone having his role. Victims role, the latest one, only 2008 CRPC recognized. Others are continuous from the beginning of British period and thereafter also. So this we have to keep, that there are role and these are the agencies. Now we are saying in criminal justice system, sometimes you use criminal justice administration, sometimes you use criminal justice system. Is there any difference identified? System and administration, criminal justice administration.
So board administration would be more specific. So
Yes?
the board criminal administration would be more specific to, like say judges, but system would include everything. Like all the different-
Police, very good. Police, prosecutor, defense, and when you say system, that means that it depends on others also. That's why pendency of the cases. No one can blame that only judges are responsible for them. Because there are agencies. I have visited last Monday in one of the oldest prison in Kolkata, Damdam Central Jail. There we have been working to under-trial prisoners. It happens that we came to know that there are not only 100, almost thousands and thousands, or more than 3,000 prisoners there. There are prisoners, the women prisoners, they are asking for free legal aid. After the applications given, not even 1 year, 2 years, they are not getting the legal aid lawyer. So their cases pending already 5 years. So they are not getting the help. So these are also responsible for so many pending cases. There are many other instances we can research and we can identify that. So there are many reasons behind that. And why it is happening, to my mind, because all the system agencies are not able to perform coherently. Our court system also not computerized, that how many cases being just for bail, waiting in the jail, languishing in jail for 5 years. That data is not in the Calcutta, at least the courts where thousands and thousands cases are pending. There is no system how to identify which cases are pending 5 years and more. We have to identify manually. That's why e-courts concept is coming, that the number in India is so huge. It is difficult to have everything manual. If it comes to your notice that yes, these are the 50 cases, more than 10 years, these women are in the jail, but their punishment may be 3 years maximum or 5 years, but they are languishing 10 years or 5 years also without producing in the court, 2 years not even produced before the court. So this type of things are happening because system, if to work, we have to have a coherent way. Like if we think of a computer, any parts of computer, any elements of computer, if not working, your computer will not work. So it is like a computer. If everyone works, then system will work efficiently. Otherwise, it will not work. That's why you have to remember that it is a system work. Criminal justice is a systemic work. Everyone to help others, so that everyone to perform their duties, obligation properly, efficiently, then only it will work properly. Police, you are not to take. Prosecutor, you have also to deal with them. Let us some aspect. No, we have all this, I think, public prosecutor, we have also, you have directorate of prosecutor also, or not? Not yet. So APP and district prosecutor here. What happened that our prosecutor training, there is no, after joining, they are in frustration. First of all, after joining as APP, they will retire. In our state, at least my students are saying, those who join as APP, they have to retire as APP. No prospect of promotion. Moreover, they have no recognition as part of judiciary in the court offices also. I have visited Alipur Court or our Calcutta Metropolitan Court. They have maybe 10-15 prosecutors. That's one room, half of this room. Only one table will given, one almirah. That is their office status. They are not satisfied with their office and job area, atmosphere. So they are dissatisfied. And there is no system of training also. What new things are coming. If one develop himself or herself, then only, otherwise somehow they are just carrying their job. So that is there. And other things, you know, there is some courtroom misconduct sometimes by prosecutors also. They are not able to handle the evidences or disclose the evidences. They are tampering with witnesses also, sometimes false, misleading evidence. These are the complaint about the prosecutors. I have no idea about your situation here, but in metropolitan areas and some other places, these are the situations. This required to be changed or reformed. defense, you know, that defense, how defense can play its role properly. The defense, the own lawyer, but those who are very poor and the research in prison population, particularly under trial prison population, is that mostly they are very poor, they are unable to engage any good lawyer. Therefore, they are own lawyers, this concept, everyone having his right of protecting or his own case, that is, they are unable to take. At what point of the proceeding they can engage, that is also not clear to the accused. And the state legal service where they are poor, state provision is there, our law is there. But I am expressing my experience that it requires 1 year, 2 years to have that type of help. And though we have in our laws self-representation, what is the literary status of the prison population? Prison population literary status, that post, if our present system of higher secondary is only about 5 to 10%. Others are not able to complete their school. So if their education level such, how they will think and protect their rights. So that is another self-representation, they are not being able to go.
So here,
Now-
may I
Yes.
interrupt? I want to inform you that in Sikkim, almost every under-trial has legal aid. I'm very proud to say that almost everybody
That
has
should
legal
be,
aid.
because I think it is small, they can manage.
And almost
and-
every woman has legal aid.
Very good. That should be, otherwise,
Almost all the cases are conducted
If-
by
if-
legal
if
aid
demands
companies.
it would be.
that is a good
So
sense, that
so
should be.
nobody wants the justice.
For languishing 1 year to get a lawyer.
Where the legal aid hasn't appointed, the courts themselves
Uh-huh.
appoint.
The lawyer of the legal aid service authority to be paid by the legal service authority.
Yes.
But that lawyer, when from jail, there is a legal aid cell in the jail, big jails like central jail. The women or the any accused have to write an application to state legal service, please provide me one lawyer. That application will go to legal service authority, they have to appoint. This process sometimes taking 6 months, 1 year.
But the DLSAs pursue these matters, so.
This,
We
if
don't
police
have that
administration, but it is a problem in West Bengal. That's why you will be astonished to know that 80% of the population in West Bengal jail are under trials. Only 20% are convict. In Damdam jail, out of this total 3,000 something, only 700 or near about that, they are the convict. All other are almost 3,200, 300, all are under trials.
Yeah, because the DLSA's SFSA is very effective because we are manageable, right?
There are cases, for example, 2,000 or around 3,000. Out of that, 2,000 require legal aid. If the under trials who are mostly very poor, they are unable. So 2,000 cases to give lawyers. One, there is perhaps restriction, one lawyer, how many cases to be given, this and that. Maybe some other, I have to look into other problems, why this is happening, that 1 year, 2 years sometimes taking to appoint a legal aid lawyer.
So you'll be interested to know in Sikkim, the state legal services has trained some convicts to be paralegals, so they help the
So,
under-trials.
very good.
So that way it's very systematic.
Acha, acha.
That was very effective also.
That I think very good idea. So let us tea and then continue. Our own domain, that your role in our justice process? You can start with pre-trial. So pre-trial stage, I think you are more efficient to give answer. What are the pre-trial stage you are to do?
So most of the time as magistrates remand,
Yes,
remand people, we do remand.
and others?
Examination of witnesses according to the statement.
But if a case comes to you, there was a refusal in the police station and it comes to you.
Refusal money, sir? To register.
The police station refused to register and a complaint came to you. That the investigation and to lodge FIR, that also you can start also. That is there. So your role is in pre-trial also. And then trial stage. Trial stage, examination in chief, cross-examination, re-examination, and then to have whether to acquittal or conviction after all this process. And then sentencing. Sentencing, we have to think we have already initiated that why punish, how much to punish. You have to discriminate. Circumstance to circumstance, individual to individual. In England, there is a sentencing act. So every offence there are specific guidelines, but in India we have no such guidelines. It is completely your own domain, and you have to apply your own decision, reason. But by step, we have to think that what circumstances you know that mitigating or aggravating circumstances, presence of that, then you can take decisions. And then you can decide how much punishment. It is not that highest punishment is there, that means always. And if you give highest punishment, what you have to do? You have to give reason why you have not awarded highest punishment in that particular case. Otherwise, in the appeal, it may be a ground that you have awarded highest punishment, but you have not given any reason. If you award lesser punishment, reasoning may not be, but you just see that in the circumstances, the accused deserve this punishment. But if you award the highest punishment, then you have to give reason. And you have to justify punishment. That's why the next is justifying punishment. You have to write what punishment you are giving, you have to write always a justification. In case of even aggravating circumstances also, you have to mention because of these circumstances which are aggravating, giving more punishment. Sentencing discretion. Sentencing discretion is in every major penal code. It is there. It is not that very few there is minimum punishment. But it is not that there is only one punishment like our previous penal system. So how to use this discretion? Normally you have to find out the first what are the circumstances in which the offender committed the crime, and also that what alternatives you have. Whether that circumstances, you know, except life and death sentences, in all other cases, IPC offences, probation is applicable. Whether that circumstances needs a consideration for punishment, particularly if the age is 18 to 21. If the offender's age is 18, between 18 to 21, Section 6 of Probation Offenders Act, it is a mandatory that the court is to give reason why the convict person not given probation. Though it is not followed in many cases, but it is a mandatory provision. So when you are sentencing discretion, that does not mean you have just to write that this sentence. Sometimes there is a mandatory provision, Section 6, Probation Offenders Act. In admonition and probation in minor offences, you can give even just warning to the particular convicted person and release, particularly women, first offenders. They are 379, 380, 81, 382. Otherwise, normally 2 years maximum punishment there. You can, it is your discretion. If it is first offenders, you can release. Or probation by taking a pre-sentencing report. You have probation officers in every district, or no probation department also not here.
I think now they have appointed probation officers.
Yes, they have.
But you're waiting there, but they're not sufficient. You don't have for all the districts.
How many districts you have? Six. Six. I have heard. In that case, at least one or two, at least one minimum required, or two.
But I think the probation officers, they're not really aware of their roles because they have to do a lot of follow-up on each person.
Each
who's
person.
there.
First of all, court is to ask, there is in other there is a format of pre-sentence investigation. You have to send to probation officer, you take the information about the convicted person, and if he is in a student, college or principal, that interview, and also neighborhood, and if employer, the employer's things, and economic situation, family situation. A report is to be submitted and your recommendation. The probation officer will give you a recommendation whether the person is fit to be released probation or not. Then it is your discretion whether you accept or not. That is PSI report, pre-sentence investigation report. But if it is there that you recommend, normally what is my experience, I had my research on probation, in 99% cases it is accepted.
In fact, here we don't. In fact, when we release them on bail, on probation, it is on the basis of submissions of the defense counsel. They make the prayer, then we consider, because there is no other.
Probation officers are not there. But I think it can be that maybe in other acts also, Juvenile Justice Act, and now after care also new bill says that community service after care, it requires probation officer. So, I think main role you have your experience also, you have to keep in mind and you have to develop that. I am coming, dependence, we are not dependence right, everything. Regarding plea bargaining, what is the status here? Plea bargaining, whether lawyers are pleading for plea bargaining? Not.
It's not very keen, not very keen. Once or twice, I think all of us in our career have done it once or twice.
Plea bargaining, but ultimately, after initiation of plea bargaining, whether it was successful, that they have ultimately reached to have sentencing and accept conviction and sharing the agreed sentence.
And most of the time we have kind of set it off with the time spent in
Mhm.
judicial custody or something like
But
that.
ultimately, result is positive or negative?
But
Not many.
lawyers are not so happy.
Lawyers are not accepting this plea bargaining to complete the case quickly. That's a problem.
Sessions cases, that nobody wants to.
Their argument is if conviction will be there, and if it is continuing examination, prosecution, they will take the case for a long time, their earning would be there. And there was now a debate whether it can be a compulsory like USA, that we have to, before trial, a compulsory conciliation. But I have not yet read whether in the new CRPC it is provided or not. Compulsory perhaps not given, but it was recommended that it should be, a law commission recommended it should be compulsory. But I have to see whether it is compulsory. Now it is under parliamentary select committee, let us see what happens. Plea bargaining, one of the way by which we can reduce this pendency. If it is properly accepted, it can be good one. Now victims of crime, victims will go. The victims now, section 2WA in 2008 defined past in criminal law amendment. In our Indian law, first time the word victim entered into the legal area. Before that, the word victim was not in our, not only criminal law, in other areas also. So it is a new phenomena, victims being defined in CRPC in 2008 amendment in section 2WA. Now question is, how far victims having right to participate in the process? It is there the victims can, in addition to prosecution, or state lawyer can add his own lawyer. But in practice, very few cases that victim, unless he is a very rich one, so not engaging his own lawyer. Special protection also, you know that for the victim is there. And compensation we'll discuss. In your state also I have seen last year, February, it is being declared compensation scheme. And victims' right to appeal. Normally what our CRPC that for appeal of any case, it lies with the state or prosecution. Prosecution will recommend whether it can be appealed or not. Even if the state not agreed to appeal, victim can also go for appeal. That is provided in the CRPC.
So just to, sorry to interrupt, I just wanted to inform you that in Sikkim for victims of POXO, the State Legal Services has appointed a special counsel, a panel advocate, just to look into the rights of the victims. During trial, he says, he or she
Very
says,
beginning.
yes, and outside the court also they follow up with the victims' requirements and things like that. So just to provide some relief to the victim.
Very good, that is an initiative that immediately there would be someone to look after.
So they feel and they are kept updated with the
All the cases.
Otherwise, they
Actually,
have
that is
disconnected.
victims. Normally what we know that accused know the development.
Yes.
But victims normally only as witness whenever court asks come. But that is now a question that how far victim be involved in the justice,
This is
criminal
one
justice
way
process.
They stay connected with the trial and they come to
In other
an
countries that
outcome.
every stage, every day, it is not only the prosecution and police to inform, but the victims to inform by the court. That provision is there in other countries, that it will go to their mobile or email. Every stage of development, they should know. That is not yet by provisions it is there, but it is desirable. Maybe it will ultimately develop when manpower we give it to the legal service authority.
It helps a great extent,
Particularly young people.
Because even if they don't get the desired outcome, still they feel that somebody
Somebody is
interested
looking
in
after
their
that.
case.
At least mental stress and others that can be minimized. Is it? So victims' position in criminal justice, which is a new phenomenon, that we have to come now. Can you just another my PPT to load?
I have one question. The definition of victim now includes the guardian as well as the other legal terms.
That should be, if it is that a minor.
Yes.
So normally guardians should come. No.
So that definition, is it for
It is in
minors
the
or-
schemes provided
Compensation.
at the purpose of compensation. But when it was defined, and it is defined in CRPC, they are only victims of crime, offense, some offense. That is being only defined, not others who are coming within or on behalf of victims. But when we interpret in operation on an application, we also included in other states also. Guardian also can claim because it is minor.
Yes, so here I just wanted to clarify because normally when the courts give compensation, we will say it is recommended, as let's say it is recommended that the victim be awarded such and such. But one of our provisions in our Victim Compensation Act, which says that
Or scheme.
no, the SLSA will determine who is the dependent. Dependent includes father, mother, son, daughter, whatever. Once the
That-
court has decided the
You have to wait for
yeah,
that.
so do they have to go into another procedure where they will decide whether it was correct or not?
Under
as to what the-
succession law, they have to, if it is if murder, child murder, rape and murder,
No, because
child.
it's specified
In that
our
case,
compensation
Mhm.
scheme. It
Scheme,
says, dependent is defined in E. E, it says includes husband, wife, father, mother, grandparents, unmarried daughter and minor children of the victim.
It is taken from the, I think, our succession law.
But to be determined by the State Legal Services Authority on the basis of a report of the SDM of the concerned
SDM.
area or the SHO. But my question is, if the court after the trial has recommended
Compensation.
compensation be awarded to the victim, including the guardian, supposing the victim is murdered,
Hmm.
so then do they again have to go into this
They have to go to
process?
this process, they have to go. So it will take more time to who is to entitled. Yes.
Another question. Dependent, the definition is different. The dependent would mean, that dependent will be who's like financially dependent on the victim or the
Now, under
emotional
whom he
dependency.
was, normally, under whom he was living, under whose supervision he was before just murder or before the crime, under whom he was living.
So for example, if there is a minor victim and she was
Living with
living with
his
her
uncle, for
living
example.
with her uncle, but she was not the breadwinner, but she just a minor
Yeah, but
victim.
it's included in the dependency.
Mhm. Depends upon under whom he is developed.
Is it, so dependent would mean somebody who actually is dependent on the victim for
Financially
everything,
dependent.
financially dependent, or is it emotional dependent?
Emotional
also?
also. It is not
Also
only,
it is financial.
not financial.
Because a child can be deprived of the mother, but the husband is also deprived of the wife. So if the wife is
If a mother is deprived of the
Child.
child, then the mother will also come as a dependent.
Mother also dependent. Mother will also come. Also.
grandparents.
Yes. I will say. Why victim today and how victim today is being considered important agency or glimpse of our criminal justice system. In fact, 1970s, one World Victimology Society started this campaign that we have so far declared rights of the accused. We have provided all the country's lawyers the protection of the accused, but what about the victims? Victims only what was before this 2008 and this victim compensation, victim was only treated as a witness, nothing more. So on that basis there are few world conferences on victim justice, and ultimately UNO in 1985 declared a declaration on victim justice. Declaration of victim justice, UN Declaration of Victim Justice, they provided in that UN declaration these 5 elements. Access to justice, sometimes victims, if very poor, not financially sound, may not come to justice system, so that support to be given. Then fair treatment, not only just support to come to the court, but here treatment is also that how he will or she will look into by the criminal justice administration. In other countries already, victims, when being called for in a court, for him or her there is a separate place to sit. It is not that for accused will be in the accused chain, in the bar, in the court, but victims having a separate place to sit in the court also. A treatment to be developed, recognition of the victim. Restitution. Restitution, we know that it is not exactly how we can give him back to what was his or her previous position, but in many other ways, by money, by medical treatment, if it is an injury, free treatment or state treatment, which you have in 357(3) perhaps. State free medical treatment to be given. So that restitution is there. Then compensation. This is completely monetary package. That why this compensation is required? Compensation is required because in many cases it is as argued by the victimologist that to keep security and safety to the citizen is the duty of the state. When there is an offense or crime against a person, citizen, that means there is a failure on the part of the state. So state is to pay compensation. Previously, you know, only 357, there is a compensation by the offender to the victim or to the state, and then it can be given to victim. But it is beyond that state to pay compensation. That a new concept being argued, that state failed to protect the citizen, so it is state's obligation to pay compensation. That is action, and then assistance. assistance in matters of court procedure, assistance in matters of information, assistance, rehabilitation, in many ways assistance. These are the things being provided in this 1985 declaration. Under this actually our 2008 took almost 23 years in our country to recognize that. After that actually in fact the Criminology Society in India, which is in Madras, 1995 Indian Society of Victimology also developed. Krishna Iyer was the first chairman of that committee and submitted paper to the government of India that in India also for victims of law and compensation to be given. That was started. Now, why compensation for that? That's what I am saying, that it is additional social insurance and also welfare measures by the law. As a welfare measure, the state not able to protect, so as welfare measure, state to pay compensation. And as we are meeting or overlooked governmental obligation to all citizens. That's why all these three reasons behind this present state compensation scheme. Previously it was only led to the code 357, that code may think compensation. And there is another, you should know that if there is a release under Probation of Offender Act, you can apply 360 CRPC, which is the new section, I don't know, but 360 also, CRPC 1973 provided that. In section 4 clause 5, there is provision that you can give compensation to the victim even if there is a release of probation. And this also, it is actually amend the laws.
In instances of acquittal, you can award compensation. When the accused is acquitted, the court can award compensation.
No, in case of acquittal, it is not there. In other cases, Supreme Court, in Ajaib Singh case, it is said. But in our Probation Offender Act, section 4 clause or 5,
Not under probation or section, probation of offenders act, but as per
CRPC.
even in the event of acquittal, you can award.
Yes, it is there on Ajaib Singh versus State of Punjab. First Supreme Court in 80s it was given that when you are acquitting, that time also you can pay compensation.
If the court finds the
Fine,
witness for loss and damages.
that is there, and it was starting in Ajaib Singh case. So here also that if to amend the laws, why compensation is required? To amend the laws sustained, loss, physical injury, sometimes medical expenditure, that is there. In other cases also loss, and counterbalance the sufferings of the victim or loss suffered as a result of victimization. So victimization, it is not equal compensation, but to counterbalance. It is not, compensation means that equal compensation, that it is a counterbalance of the sufferings of the victims. That way compensation to be think of. It is not compensation exactly the same. Like in contract, breach of contract, you have to see actually the what actual loss. But here it is not that. Now, another thing, it carries with idea, making whole or giving an equivalent substantive material payment to one party has no relation to any advantage to the other party. It is not a distribution of advantages and disadvantages. It is a substantive material payment to the party for the loss suffered. We will not take it as the loss of one party and it is a benefit, advantage to other party. That way we will not think of compensation. So compensation will perceive as counterbalance the suffering, as substantive material payment, which is not equivalent, but and it is not an advantage to any party. Up to this we have. Now come to our CRPC. We have 357 also. 357, how you have experienced, how many cases you have given compensation. You have that discussion. 350, only 357. 357A is present, gives compensation. But 357 also, if you see, provided. Can anybody, madam, you can read 357 or anyone?
When a court imposes a sentence
But
on
can you louder, others are not.
or sentence, including the sentence of death, of which fine forms a part, the court may, when passing judgment, order that the whole or any part of the fine recovered to be applied, A, in defraying the expenses properly incurred in the prosecution, B, in the payment of any person of compensation for any loss or injury caused by the offence, when compensation is, in the opinion of the court, recoverable by such other person in civil court. C, when any person is convicted of any offence for having caused the death of any person or having abetted the commission of such an offence in paying compensation to the person who are under the Fatal Accidents Act 1855, entitled to recover damages from the person sentenced for the loss resulting to them from such death. D, when any person is convicted of any offence which includes theft, criminal misappropriation, criminal breach of trust, or cheating, or having dishonestly received or retained, or having voluntarily assisted in disposing of stolen property, knowing or having reason to believe the same to be stolen, in compensating any bona fide purchaser of such property for the loss of the same in such property is to be restored to the possession of the person entitled thereto. Number 2.
Yes. So the gist of this, that there are provisions that we can think of paying compensation by the court. The 357A is only through the State Legal Service Authority. But court can also provide compensation in case of conviction and where death or other offences, it is provided that you can give that. Punish with sentence of fine or with fine is form part of sentence. That is specifically there, and where a person entitled to recover damages from convict through fine, though fine is not part of the sentence. These two are specifically mentioned where discretion is given to the court, you can pay, ask to pay compensation by the accused. But this is also, I think, you may think where you can award. Is any experience, any of you, madam, that you have awarded 357, any compensation?
I may have awarded when I was
So many years not remember. But I would suggest,
Share one experience.
can you just take the...
When we were trying a case for rash and negligent driving, 279, 327, which is minimal fine. I do not remember now, but there was minimal fine. But the person who was injured, or the child who was injured, had suffered quite a lot of injury. And
Yes, that is, I think that 357 plus 3.
So he
That where damages can be awarded, but fine is there. But you think that there needs more damages, more compensation to be given, you can apply this.
One problem that I think the magistrates court is facing is that supposing they want to defray the fine and impose fine and say you pay to the victim, the accused does not have the means to pay fine.
That is another issue.
That is one of the issues that
That is also an issue in many cases.
in many cases
That
happen.
fine is there, but unable to pay fine.
Yes. So you would rather go for the default?
And in many cases, I have read one research paper that in a district that the husbands prefer to go to jail than to pay
Yes.
the maintenance because that is easier for them. So that's a real social problem is there. But the provision is there where it can be applied. You can think where it can be applied. 357 only, but it is also in most of the literature you will see that it is not being very much used in our Indian compensation jurisprudence. Another is 358, groundlessly arrested, malicious prosecution which we normally call. Compensation is only 1,000. Those who suffered, they had also not come to the court because for 1,000 he or she is to incur maybe 10,000 or 20,000. So that is why this provision also not in use. Though provision is there, this malicious prosecution, court can pay compensation as 1,000. Very few cases it is being used. Now this 359, it is also there. The appellate court, high court or the court of session can order penalty in cases of non-cognizable offence and cost incurred due to prosecution. That is also this false prosecutions you can pay compensation by the appellate court. There is another compensation of filing of cases lacks reasonable ground. This is in 237 clause 3. Court of takes cognizance of an offence under 199 clause 2 and found that there are lacks reasonable ground, court may order to pay compensation not exceeding 1,000 only.
Maybe now all these will get amended to...
Now this amount definitely to be amended. Otherwise for this 1,000 it is not, I think, reasonable or acceptable to person to go to court.
Because of these legal amounts, these provisions are all redundant.
These provisions not being redundant. But these are also useful. When it was made, it was useful. But now, in the present, the money value, it has not been
Income more than 1,000
to court. Yes, for 1,000 rupees. But sometimes in Calcutta, I get one in Calcutta court. Somehow, if one is looking to at least to prestige that yes, you have been wrong, I will prove that you are wrong. So that's sometimes happening. Those having money, they may come. Now here a person who suffers loss or injury which is caused to him by an act or omission for which the person who is accused has been charged. So when a charge being framed, the question of victim and compensation will arise. This definition indicates it is also victim means victim of offence or crime. So charge being framed only against the accused. Another we have to remember section 24(8). Right conferred on the victim for engaging an advocate of his choice to assist the prosecution. But most of the cases, the victims are poor, normally not. But it is now being used in some cases. In Delhi, I have read a case that he was first not allowed to engage with the prosecution. But ultimately, the High Court interfered in the division, yes, you have to. You can't deny. If a victim asks that my lawyer will be in the prosecution along with the prosecutors, it should be allowed. It is there clearly in section 24(8). Then appeal, 372 CRPC. Victim has a right for engaging an advocate of his choice against an order of the lesser or inadequate compensation. That if the victim is not satisfied with the order, victim has a right engage an advocate for appeal. It was a new concept that victim having right of compensation and right to appeal to the higher court. Now we may come to 357A. The state government in coordination with central government obliged to prepare victim compensation scheme. Now almost all states frame their compensation scheme, and central also paying particularly from the women victim that amount to some extent they are assisting to all the states. Nirmal fund, there was a Nirmal fund created, and that fund not being able to incur expenditure for that, and that is now being distributed to all other states. District and state legal authorities decide amount of compensation as per the recommendation of the court. That is being followed. And now interim compensation also developed in the scheme. The problem is when I was in Odisha, our LLM students conducted some survey on compensation under the 357A. They are also reported that in many cases the interim compensation gave him maybe 25,000 or something, where the total compensation maybe 3 lakh, 5 lakhs, whatever.
Mostly it's at 25,000.
After 25,000 or 50,000, 3 years, 4 years, no other payment. That problem is now developing. When interim relief being introduced, that another problem is after interim relief, the total package of relief, the case continuing but they are not getting. That is another problem from this procedural level developed. They are saying, I talked to the SLSA, they are saying that we are not getting the fund. I had a talk with the present Chief Justice of Kolkata High Court, Sivagnavan, that when he was the chairman, we had one project that why the data in the website not available last 2-3 years. Yeah, he replied that there was no fund provided to us. What will give? That no fund will disburse. If no fund available from the government, what will write? That they are also facing that problem. The funds not coming from this, particularly these 2 years between COVID period, funds was very much in crisis. So that's another situation. Another is that first aid medical facilities and benefits to be provided to the victims of crime. It is not known, I think, many citizens also, that for any accident, whether private or state, all the victims of accidents or even rape victims or any victims of bodily injury, they can go to any hospital and free treatment to be provided. Private hospitals not do it, but state hospital in emergency they are giving. But it is as of right, matter of right now, that it is provided that all medical, first aid medical facility be provided to victims of crime, both in state hospital as well as private hospital, nearest private or state hospital. That is, awareness is actually needed. That if it is known to people, they can easily, quickly go to any hospital and they can ask that. Private hospital, I engaged one of my researcher from our university that whether private university, private hospital authority knew it. Authorities there, no doubt we have not such obligations. They are not aware, yes, under law, they are obliged to treat any accident patient in their hospital free of cost. So that is another problem we are facing, awareness of the rights of the people, rights of the victims also. 357B, another we have to look into that. Under 357A, what is being paid? In addition to the fine to be paid to the victim under section 326A or under section 376D of the Indian Penal Code. So this, you remember this 326A and 376D, whatever compensation under this 357A, this should be treated as addition. So whatever fine court has liberty to give that. It is not they are getting compensation from the state legal authority. Fine is not to be included. That is not. It is in addition to what is given under 357A. That we have to follow. 357C, which I was just telling, obligation on all state or private hospitals to compulsory provide immediate free medical aid to the victims of offences, particularly under section 326A and 376 to 376 ABCD of IPC, and then inform the police. So this, I think, require more information to the public, that 376 in any type of the ABCD, whatever type of these rape victims, and also 326A, immediate medical treatment to be provided by private or state hospital. This is required to be known. Actually, this is taken from that UN Declaration 1985 that is provided. That treatment, they are saying treatment, that treatment to be provided. It is taken from that UN Declaration. As in Section 5, offenders that it is provided that also compensation, victim compensation. Motor Vehicles Act also there, and PWDB Act also compensation is given, but this is a separate compensation jurisprudence under our various other laws. Now, administrative scheme are also there in compensation. Security related victims at the hands of Naxalites, the government of India in 7 states, 76 districts, fortunately your state is not covered within that. The National Foundation for Communal Harmony and Corpus Fund by Government of India for victims of communal riots, violence on caste and ethnic issues. That compensation fund already there. And another scheme for relief and rehabilitation of rape victims now merged with Central Victim Compensation Scheme. This CBCS mentioned, you will see in your scheme also, that for compensation of victims, whatever state budget is given and whatever provided by CBCS, Central Victim Compensation Scheme, both to be merged, given. It is not only what is given in the state budget, that to be covered and that to be disbursed to the women victims. So CBCS also one of the important elements to women victims. And And it is mentioned, I think, all the states because they are getting fund from the center. Problem is compensation under 357A. Different state having different compensation. And you know, under our Article 14, or to be treated equally before law. That for victim of rape, if one is paying 5 lakhs, other is paying 10 lakhs. A clear discrimination is discernible. So for that, so compensation different amounts, different offences. Supreme Court in Loksmi versus Union of India in 2006 pointed out the compensation as inadequate and not uniform. In another victims of rape, it was pointed out that compensation you can't discriminate. If same situation, you have to provide same compensation. Article 14 you have to follow. It was provided that following that our central government of India in 2015, this CBCS actually compensation fund, now scheme, but it was first CBCF, now we call it CBCS. And uniformity, it was introduced from 2016, that compensation whatever states are giving to make the equality among other states, the central fund to be used. Now if, for example, in your state it is 7 lakh or 10 lakhs, 7 lakhs perhaps, other state is 10 lakhs, that 3 lakhs to be given from this central fund. This way attempt being made to make the equal treatment to all the victims. That is started from 2016. Now about the victims compensation, what is the position in our country? If we look into other countries, we will see that in USA, UK and India, it is state as well as the offender. Offender means our 357 offender can pay. And in other cases, you know, Supreme Court, even High Court, in rape victims cases, beside 357, can ask the either if it is under state custody, ask the state to pay compensation, and sometimes the compensation they ask to any organization also. You know, there are cases of in Howrah station, the Bangladesh women being victimized in the railway Jati Niwas, Isham Das versus Union of India. Supreme Court awarded damages also. So it is that court as well as the state court award compensation to be paid by the offender. But our state also liable to pay compensation to the victims. So one type of compensation is that both state as well as offender. There are some countries where only state compensations are there, like Australia, Canada, Denmark, France, Sweden, United Arab Emirates. These are the countries where only states pay, not the offender. States paying compensation in their law. In few countries, Australia and Belgium, state not paying any compensation, only the accused paying compensation. And there are others, it is not very clear in the law who is to pay compensation. It leaves to the court. Court sometimes give it, or state on their own side. Some cases they are paying compensation, not any specific schemes or guidelines are there. These are the Colombia, Germany, Spain, Czechoslovakia, the Portugal, Switzerland. There is compensation is there, but who is to pay, that is not there. That means there are certain, I think, gaps in the law. So trends of recognition of need to pay compensation of victims more and more rights based rather than grace. That compensation is not a grace but of right. The victims, when we recognize in the law, that means legally protected interest, that law protected, like our CRPC now 357A, it is a state obligation and it is right based. So that is there. Now what is the challenge? I will go back to previous one, the administration of justice. First, before that, any questions on doubts about compensation to victims under victim compensation scheme? You have started, very few occasions I think you got to have this claim. You have already got this claim, compensation by the parties, victims.
So actually, as a magistrate, I have not imposed anything so far,
Not
which I think is very routine for sessions court and
it is
special
just
court.
started. I think gradually the lawyers will also know
Yes, sir.
and they will claim that.
Yes.
And the women also, they will also come to know.
So, and I think this is precisely why plea bargaining is not very popular in India. Like in the USA, plea bargaining comes with a lot of damages or compensation
Yes.
paid to the
If
victim.
plea bargaining made compulsory,
Yes, in India it's like,
then I think the present crisis of pendency and this under trial, so many prison workers, this will be minimized. But problem is the lawyers not accepting plea bargaining and government also not able to increase the infrastructure of the prison. Huge expenditure. Somehow they are managing that within the previous, I think, if I go to our state, only one, last 20 years, one new prison. Others are mostly after independence, within 10 years, it is there or British pure. Every district, there was a jail constructed by British. So, but the new buildings for the jail, that is not priority area. So that's why jails are not increasing, but number of crimes increasing, criminals increasing, and court also overburdened with the number of criminal cases. Disposal through our due process of law. Due process of law, every opportunity to the parties to prove that he is not guilty, and beyond reasonable ground. Beyond all reasonable ground, you have to prove. So that is another area, not the possibility of proving. It is that every sentence or conviction you have to prove on the basis of all the documents. If there is any doubt in any witness or evidence produced, there is a benefit goes to the accused. So that's create a problem. Conviction rate is low. I do not know your state. In our state it is 25% average. What is your state? Low also. In India, only Madras, now it is Karnataka also, rate is to some extent high. But most of the state it is 25-30%. So
benefit of doubt. Benefit of
and
doubt
you have to prove beyond all reasonable doubt. And that philosophy that let hundreds criminals set free, not a single innocent person be punished. That philosophy, due process of law is continuing.
Especially in cases of NDPS.
NDPS example.
Although there is that reverse burden on the accused, still
Ah.
here we have a state act also. almost every other case because of
To
very poor investigation.
beyond,
Poor investigation.
sometimes it is intentional, sometimes not intentional. That we know. And also non-acceptance of scientific evidence. Even the expert evidence by the forensic lab, it is not, you can sentence on the report itself. That would be against challenge, because that is a corroborative evidence. So it is not treated as primary evidence, you can convict on the basis of, which in other countries, European countries, the expert evidence or evidence of the technology, the DNA evidence or other forensic evidence. On that basis, there will be no doubt, because they think 99% scientific proof is there, so we will accept it. But in India, criminal jurisprudence is not accepting that. Still now it is corroborative, you have to prove that it is correct. So that's doubt and debate is there. Now, what are the challenges now? Let us go to the last slide. These all cases, I think all of you are aware of these landmark cases. George versus State of Maharashtra. This case is that when a law being developed or a new rules to be developed, unless it is published in the Gazette, and what happened, the George, immediate George, came on the day, that day itself the law being declared. And you know that a law when published in the Gazette, for example, if it is published on today's Gazette, what is the name of your Gazette? Sikkim Gazette. Today it is being published, Sikkim Gazette. Now, when it will be come into force, it will be from the midnight. The date it is announced from the midnight, not that when it comes out from the press. Under the General Causes Act, a law when announced or a notification when announced, that will come into force in the midnight. That's why you know when there is a petrol rise, from the midnight notification it is an operation. Law also same in the midnight. In George, what happened that he entered in Mumbai in a flight from other countries, and when he landed, he possessed some foreign currency which was beyond the limit, and that limit being changed on that day. So argument was that whether he can be punished on that. What was in possession, that was under previous limit, but new limit only from that day it is being imposed. Ultimately, court held that he should not be punished because publication means that reasonable opportunity to giving to the public to see it. The notice of presumption also, that if you keep it in the press and it is not published, so how people will know that it is coming to force? Only in the newspaper, if it is published that President assented, that doesn't mean it come into force. The day it will come into the official gazette, then only it will come. So that way, because we know our constitutional principle, criminal law can't be ex post facto. Our constitution says criminal law can't be you can't apply a law retrospective. So when it happens, it should be prospective in nature. This should be. Archanara Khatun, you know also that Bihar case that the accused not produced or released, though court released the woman. After the court order also, almost 14 years she was languishing in jail. Then from NGO it comes to the knowledge of the court that she was detained even if there was a release order by the court. That was not communicated properly to her and family was very poor, no one taking care. So she was then paid compensation for this lapses of criminal justice administration. Sunil Batra versus Delhi administration, custodial torture in the prison, Tihar jail, that Sunil Batra being beaten in the jail, solitary jail, and she filed a case that first of all solitary confinement is not mentioned in our criminal law anywhere. It is in jail manual, but not there. That was in question. And another is torture, that you can't physically torture anyone in the custody. So that was against the jail authority, Delhi administration. Bhim Singh versus State of Jammu and Kashmir, a compensation even for the though political arrest. Bhim Singh was arrested on the day of session going on. No confidence motion was in the assembly and he was detained on some preliminary ground and released after next 24 hours, one day, under police custody. Then legally the court declared it is illegal arrest and also tell that state to pay compensation for illegal arrest, not 1,000. A huge amount was given for compensation by the state, by the Jammu and Kashmir state. Joginder Kumar versus of UP also, there is arrest, Joginder Kumar. Here the arrest from one jurisdiction, and when there is a release order that you can't be realized that can be detained. Released in the jurisdiction of other police station again arrested. So 24 hours, one can arrest within 24 hours to produce. If it happens that within 24 hours, one police station released, but other police station arrested him. Whether his count would be again newly or continuation. It was said that it should be treated as continuation. You can't just for the sake of legal or constitutional provisions, lip service to the provision that you just release and immediately arrest. Or sometimes what police do, one section may be arrested, then another case filed, released, in that case if courts are released, another section, heavier sections also given and arrested. So that's things Supreme Court said it is not permissible. Bodhisattva Gautam versus Supra Chakrabarti under 125 maintenance case also, that when case was continuing, interim relief was awarded. That from there, it is there that if there is a maintenance case, that within that interim period also compensation can be given. That is started Bodhisattva Gautam. D.K. Basu, you know that regarding arrest or what are the minimum procedure to follow. A huge guidelines and that required to be put in the jail also. That is the Supreme, but I have not seen it in the police station. They have placed these D.K. Basu guidelines which Supreme Court held it should be placed in every police station. What are the guidelines to follow by the police station in case of arrest. So these are the very challenging guidelines, and present is hydra-headed justice system. That you know, from the magistrate court, it can go to even district judge and to high court. In case of session judge also, it can go to revision to high court, and sometimes with high court order or high court even appeal judgment, you can go to, particularly in case of life imprisonment, question of law can be raised. What happened in Juvenile Justice Board, where a joint offence or group offence, one of the member of the group is a junior. His case or her case would be in Juvenile Justice Board. So what happened, I have seen such cases in Kolkata, in Puri, reported cases, that in a dowry death case, the sister of the husband, when there was a case and it was ultimately trial court to high court, every punishment, and it ultimately reached to Supreme Court, and the sister, his sister ultimately also accused, and her case was continuing when she was 34 years of age. That time, juvenile board in Calcutta, the case came from the High Court, the records came from the High Court. It was procedure at that time. I do not know your procedure here. If there is a group offence, the juvenile case would be started after all the disposal of the adult cases, all the original documents comes to the juvenile board. And that was followed that time. Now it was changed, the certified copy can be taken. But when it was in 2007, it was pointed out, then I think circular was given by the court that yes, certified copy can be taken. Otherwise, they will language that juvenile, after when if it is a person having money, go to High Court, to Supreme Court, and her case remain pending. At the age of 34, she is being attending the juvenile board course. So these things was there. The huge pending cases, everybody was very much annoyed with the figure, 5 crores pending cases. When it will be disposed of, we do not know. And delay in justice process. I have seen, I can show you it there, that in a domestic violence case, 498A case, the wife complained that file case, and the summon of the case took 2 years to start the case, and thereafter, one after other grounds, either this lawyer or that lawyer not coming or taking dates. So 9 dates being taken. This way, other witnesses also mostly lost interest, and after almost 10 years, it was decided that for want of evidence, the accused is acquitted. So is it the 10 years required for judging a 498A case? And it is not one, I am just giving one case I have just published in Delhi Law Review also. That one case 498A, how it will take 10 years. We are not able to restrict the adjournment. If you, particularly I know in some courts in West Bengal, adjournment, my students, particularly girls who are, so it is very difficult for us to refuse adjournment. There will be false complaint against me to the High Court, and there will be boycott. I will be transferred to some other distant places. So these are the practical problems. These are not written in law, but these are the practical situations. So day after day they are taking adjournment, or police is not serving, or court server not serving the process, summon process. These things, human inefficiency and corruption both going on. It is not that our law is defective or courts are not effective or functioning. Lot of other things are there. Sentencing disparity and delay in getting forensic report. That is another issue. Particularly in Kolkata, Odisha, I think now even CFSL having no DNA scientist. They have to send it to Hyderabad.
We have to send to Gangtok, Assam, Hyderabad, Chandigarh, Kolkata, and all of these.
Kolkata now, that DNA scientist being transferred, there are no DNA tests in Kolkata also. They are sending to Hyderabad. But you know the rape cases being increasing every year. Last 5 or 10 years, if you see, it is increasing almost from any other offense, most increasing offense. After, I think, another is cyber crime is increasing, other is offense of crime. And DNA evidence, if quickly, within 6 months at least, can be given. But that is for want of our technological support, we are not getting. Court, in many cases, giving that. That is to give the report, that is another, and after report also there will be debate whether it is acceptable or not. So that is another our challenge. Discretionary power, sentencing disparity. That is another that I have seen in one district for theft sentences are within 1 to 3 months, even 15 days. 15 days to 3 months. But in Calcutta it is mostly 2 years, 3 years. How we can have one type of offense? Do we know that circumstances to be considered in it? But if we see that in one court, all the cases are within 1 to 3 months, and other district it is minimum sentence is 2 years. That means there are some attitudinal or behavioral aspect, mental attitudinal problem is there. Either this particular district, the people or the offenders, they are some categorized, we do not know why this is happening. This is being also observed in the Supreme Court. The sentencing disparity to be minimum. I do not know in the new act whether there is any. It was proposed, I have seen in the proposed draft, which is prepared in NLU Delhi. There will be list of probable sentences in sections. Whether it is accepted by government, I have not seen. And the last one, corruptions that in police to court to prison. Prison, I just Monday I have seen that in some cases the convicts or the under trials allowed to get some foods outside, it pays money, and those have no money, they have not availed that. Or in case of foods or facilities in the prison also there is disparity. In case of, if you see the access to court justice also, even up to Supreme Court for bail, one can go within 3 days of arrest. But others, they are languishing in jail for want of lawyers. We have in our system that there is no system that whose case first started, that to be taken first. A discretion is given in that you can decide, particularly the higher court I am saying, not in the lower judiciary. Higher court, they can take any case, even sometimes if it is politically very sensitive case, that will go days after days, and other all pending 5 years, 10 years cases remain pending. So this type of things are continuing in our system, justice system. Within that, let us hope how hard reforms proposed, whether it will help. As you are in the part of this system, I know from your socio-legal perspective that you are doing best. Try to think that those who are victim as well as accused, they are treated equally under our constitution. Now any questions or doubt you have?
So I just want to inform you that in Sikkim, regarding this last topic that you're talking about, not only in Sikkim now, almost every high court has an arrears committee which monitors pendency, and then they instruct the courts to give priority. First we have under trials, when we have a category, children, whatever, then senior citizens and things like that. So the arrears committee chairperson,
We are
monitors.
looking into the trial court data also.
Yes, and all the oldest cases, so we get instructions here, you expedite
But
this
it
case.
is not yet developed in West Bengal, I know.
So here it's very effective.
If it can be done, even district wise also, if district judges can do that. Similarly in prison also. Actually our university being asked by the state government to involve our students to work with the legal aid of the state and the district to help that identifying those who are at least 5 years and above, to identify those cases and why they are in the code. One aspect I have learned from visiting, that what happens sometimes or many cases, the police taking them from the jail, recording for production in the court. What the undertakers are saying, they are taken near the court and they kept in the court custody, not produced in the respective court, and then return. So this way, again and again, 1, 2 years, 3 years, they are not actually produced before the court. They are just taking from the car, put up in the court lockup, and particular court distribution, all those accused, that is not happening.
Just to inform you, in Sikkim, our practice in the courts is that in a cause list itself, the cases are prioritized. For example, under trials will be taken first, then POCSO cases, then fast track court cases, and cases of senior citizens.
That is
So it
the
gets-
prison will decide or in the court
No,
itself.
the court staff have to sort out the different cases, and in a cause list they have to prioritize. So we have.
Here pending case, I
the cause
think,
list itself.
less in that case
Yes.
compared to other
Other
states.
naturally, it's manageable.
But at least if system is there,
But
that
if the system
pendency
is
will
put
be
in place,
at least injustice should be less. Otherwise, those having money, they will manage to out by bail or others and get more advantage even in sitting in the prison. That is not desirable. Any other? Okay, you are the last, I think, entry in the service. How many years you have entered?
I recently joined. It's been 2 months that I've joined. But
Only 2 months. So
1 year training before.
1 year training is going on.
it's completed
Oh,
and then I
completed,
joined.
अच्छा.
Our youngest members are women.
Achha,
They are
both.
the youngest members.
Yes, अच्छा, good. So you are from your government college or other places? Your LLB?
KIT, sir.
KIT. So when? I was there that time.
You were there, sir.
So that's why I'm saying over there, I saw your face. Okay. You graduated in 2020 or when?
2018, sir.
Huh?
2018.
1918. So when I was there.
Yes, sir, you were there.
Okay, Zola is our PhD student, so I will talk to you after.
Yes, probably in September.
Thank you,
sir.
thank you. So your degree is yet to
So
offer.
I think I'll submit my first draft in September. I've requested for a pre-submission cool documents. I've sent a mail just yesterday.
I think maybe within either October or by December, some December.
Yes, sir. Yes, sir. I intend to finish it in this semester, so I'm also like fed up of doing it.
Okay. Thank you. Any other? Thank you very much for sharing your thought. I was also learning about your thing, some good system also. I think because of population and small area, I think you can manage and develop a good system. Thank you all. Thank you.
Thank you, sir. I would like to thank our resource person for today, Dr. Nirmal Kanti Chakrabarti, for his insightful session on victim compensation. As a layman, I also learned a lot. Thank you, sir. I would also like to thank all learned judicial officers who have participated in this event and made this a successful one. Also, I would like to thank all the staff of SJ, all the catering staff and the photographer for working behind the scenes. With the permission of the learned director and the resource person, I would like to end this session. We'll gather for a photo session out here itself and then to the recreation room today for lunch. Thank you.